For admission, item numbers 1 and 2.
Yes, who appears?
May I please, my lord?
Yes,
My lord, I am appearing, my lord, for item number 1, my lord, the writ appeal.
that's right.
And the connected contempt, my lord, my learned friend S.K. Medhi, my lord, he is also there online.
Yes, I can see
My
both.
lord, yes, my lord. My lord, here the basic issue, my lord, is regarding, my lord, the payment of interest.
Yes,
My lord, the landowners, my lord, herein, they have been, my lord, paid, initially, my lord, they have been paid the compensation for only for the crops. My lord, thereafter, my lord, some of the petitioners, my lord, approached the reference court under section 18. And my lord, there the value of the land was, my lord, directed to be given at rate of rupees 25. That is from zero. Initially, my lord, the land value was zero on account of the fact that, my lord, that these landowners, since they are having periodic pattas, my lord, they will not be entitled to the compensation, and it is only the, my lord, land settlement certificate holders who are entitled to the compensation. So, my lord, thereafter, accordingly, the value was enhanced, my lord, from 0 to 25, and they were paid the due compensation, my lord, and for that enhanced, not enhanced, my lord, for the redetermined value, my lord, I would rather submit, my lord,
yes,
the redetermined value of land compensation. My lord, thereafter, my lord, I take, my lord, to
make your arguments first and then take me to the relevant portion.
yes, my lord.
It's basically the principle is involved, but you have to give certain
Yes.
facts. Yes,
Yes, my
what is the ground that you are formulating against the order passed by a learned single judge?
My lord, the basic ground is that, my lord, interest under both section 28 and 34 would not be admissible, and the interest can be paid only under section 34 to the landowners.
Now that's a very broad simplification that you have made. On that argument you may not succeed. The argument is something else. Let me put it, because what you have formulated is not the question which is really important.
My lord.
There are two things.
My lord.
You know, under 28,
Yes, my lord.
the grant of compensation is discretionary and it is only on the enhanced compensation, assessed by a reference court under 18.
Yes.
So therefore, these are complementary, 28 and 34. Suppose in the year 2015, a
My
land was acquired,
My
correct?
lord.
A land was acquired and the compensation paid was in 2020, that is after 5 years, rupees 10 lakhs.
My lord.
The reference court enhanced it to 15 lakhs. So interest under 34 would be paid on 10 lakhs from 2015 to 2020, and under 28, if the court says so, it shall be paid on rupees 5 lakhs, the balance amount from 2000 from the time that the enhancement is made.
Yes.
Correct?
But
So
that is
therefore
not the case, my lord.
therefore
Yes.
both can go together. Therefore
Yes,
your
both can go together.
Therefore your
Both can go
argument,
together.
just a minute.
My lord.
Therefore your
My lord.
argument is that here there was no enhancement as such. It was
Yes,
zero in the first instance because they were only paid for crops and not for the land because they were holding patta.
My lord. My
And
lord.
then it was found that no distinction could be made with respect to that, and therefore the compensation was paid under 34. So in this case, this complementarity theory would not apply. That's your argument.
That's me exactly.
So you have to formulate it now.
Obligation, my lord.
The court will not do it for you. The court will not do it for you. You have to formulate.
My lord, I
Yes,
was
Mr.
coming
Malhotra.
to, my lord has summarized it. I'm grateful, my lord.
Yes, Mr. Medi. If Mr. Medi, you would. He's Mr. Medi, no?
Yes.
Yes, madam.
Mr. Medi, contempt lies only when we uphold the
Yes.
order passed by the court. All right. Yes.
Yes, madam.
All right. So hold on. Hear the argument of Mr. Malhotra.
Your Worship, just to bring the facts to your Lordship's attention, initially there was an award, award 1 of 2012. In that, a number of landowners were given compensation for crop damage, and then a certain number of the landowners preferred a reference petition, where the reference court held that they are entitled to land value also at the rate of 25 rupees per square feet, which was given to 2 landowners holding land settlement certificates. So as per the direction of the reference court, those persons who had preferred the reference petition were given 25 rupees per square feet, along with solution and interest. Then those then the present writ petition, the present respondents had also approached the collector under 28A, which was rejected. Then they approached this honorable court, the High Court. The High Court directed the collector to consider the case afresh. Accordingly, they were given the land value by the collector on the basis of the order passed by the reference court. Then those petitioners who had earlier approached the reference court, they filed a miscellaneous application in the reference petition, claiming interest under 28 and 34, both. The reference court passed an order that they should be paid compensation under interest under 28 and 34. Accordingly, those petitioners who had filed the reference petition were given interest under 28 and 34 by the railways. Then we came to know that on the basis of the miscellaneous application, the other landowners have been given interest under 28 and 34. We approached the collector. The collector then stated that yes, you are eligible under 34. 28 is a different matter. So the collector passed an order that we should be paid interest under 34, which was given to us. Then we moved a writ petition.
Same process followed.
Yes. Then we moved a writ petition claiming 28 interest. The writ petition was not objected to by the railways. The Honorable High Court held that the collector should decide the matter. So the matter went back to the collector. Then the collector passed an order directing that payment of Section 28 interest should be given to us. That judgment of the High Court directing the collector to consider our case for interest under 28 was not challenged.
No, that is not required to be
Yes.
challenged.
So then 28 interest was granted by the collector. Now they have come up saying that the interest
Therefore
has to be
they-
either under 34 or 28.
No. Now, therefore,
But-
I gave that example.
But Your Lordship, just one thing which I'd like to state is in the writ petition, which was filed before the learned single judge, the stand taken by them is that we are not entitled to 34 interest. We are entitled to only Section 28 interest.
That stand
I mean-
means nothing.
They're contradicting their stand. And they said that the interest which was given to us under 34 should be adjusted against interest under 28.
That stand they cannot take, and if they have taken that concept is ill-conceived. Ill-conceived petitions, we don't.
Now they are saying, in the writ appeal, they are saying that no, we are entitled to interest under 34 and not under 28.
That's right.
Yes.
So I gave you an example. If you can find out any folly in the proposition which I am telling you. Now, suppose a land is acquired in 2010,
Yes, yes.
right? Money is paid under 34 in 2020.
Sorry,
Land is acquired under 210, possession taken under 200 in the year 2010.
2010.
The collector assessed the quantum of compensation to be 10 lakhs.
Yes.
But this 10 lakhs was paid in 2020.
Okay.
Correct?
Yes.
So under 34, he gets 9% compensation plus the addition of 1 year each from 2010 to 2020. Right?
Yes.
And the reference court, finding that 10 lakhs compensation was very bad, it was less. So reference court says that from 2015, reference court decided it under 2015, that it should be 15 lakhs. So there is an enhancement of 5 lakhs. Only interest on rupees 5 lakhs, this is discretionary, the courts can grant, but this will be only from the period 2015 to 2020. That is from the date when the reference court makes it. And that is why they say that it is complementary. That's the standard, understanding. You don't need to go to many laws except Sundar 2001 that makes it very, very clear.
Yes, Your Honor. It's supplementary to each other.
Supplementary in what circumstance? Suppose
Yes.
you would have been paid. The situation here is that you were not paid at all.
Yes.
Considering that land does not belong to you, you were only a patta holder.
But the reference court held that no. we are
Reference court only asks, reference court decides. But here is a question where the single judge did not agree to the prayer made by the appellant state that, well, the reference court was wrong. Otherwise, Mr. Malhotra, you
Yeah.
would be getting 18% interest, whereas others would have got only 9% interest.
Your Worship,
So it is, here the 28A and 34, they merge because you did not get anything. Suppose you had got only, see, you were paid only for crops. So that is no value for the compensation of land.
yes.
Now, there can't be any unjust enrichment with respect to the others. The others also got, you did not get, you challenged. That distinction was blurred by the Superior Court. Rightly, wrongly, we don't know. But then that is not under challenge, we are not questioning it. Now, you get compensation straight away under 34 for the period that you have not got. Even though you had approached the reference court under 18 considered and asked the collector to do it, but then the collector has passed an order without understanding that it was never on an enhancement, it was on the first assessment. You were completely excluded. Am I clear to you?
Yes, sir.
So that is what Sundar says. If you read Sundar carefully between the lines, they say it is complementary. Why it is complementary? Suppose you would have got it in 2010, say only 10 lakhs. In reference, they would have, the reference court would have directed, and the DC under the orders of the reference court would have considered that no, you are to be paid 5 lakhs more. So this interest would get on 5 lakhs only and not on 10 lakhs. It is only on the enhanced rate.
Enhancing.
You get 5 lakhs, and from which date? The crucial date would be the date when it is decided that you are entitled for compensation on an enhanced amount. So that date becomes crucial, and from that date you will get. Even though you have got it in 34, you again get on the enhanced amount. Here there is no enhanced amount. In the first instance you get 34. So can there be, what would be the crucial date now? Suppose you say that under 28A also you be given 9%, and under 34 also you are given 9%. So therefore, you know that 28A is not from the date of it is from the date when there is a judgment, when there is an order for enhancement. So you have to, I mean, it is only under 34, and 34 is better because 34 you get solatium, you get an enhanced interest after 1 year, after 2 years or whatever, under the scale. So this is wrong.
Your Worship, 28 is from the date of possession.
No, sir.
As per, Your Worship, if
No,
I may
sir,
read-
no, sir. No, sir. Please be very clear on
Yep,
that.
yep.
It can't be from the date of possession. That's not the scheme of the Act. Let's see 28 here.
28.
Sir, you agree?
If I may read 28, Your Worship.
Yes, 28.
If the sum which, in the opinion of the court, the collector ought to have awarded as compensation is in excess of the sum which the collector did award as compensation, the award of the court may direct that the collector shall pay interest on such excess at the rate of 9% per annum from the date on which he took possession of the land.
From the date of?
From the date on which he took possession of the land to the date of payment of such excess.
So that's right. From that date.
Yes.
Okay.
So from the
Conceded.
date of possession.
Conceded from the
Yes.
date of possession.
Yes,
And the interest would be on the enhanced amount,
yes, that,
not on the whole amount.
not the,
Now,
Yes.
agreed. I thought it is from that date only.
Yes.
So, sir, therefore, if this, where is the question of enhanced amount? How do you get this enhanced amount?
Your Worship, to my understanding, Your Worship, earlier it was 0. Then, as per the reference code, it was enhanced to 25. Earlier, we were not
So
paid any
you
land
are
value.
getting 25 from the same date. So it falls in 34. Or if it falls in 28, then 34 you forget. Can't have two things, no.
No, Your Worship, in fact, Your Worship, if I may take a...
Let us see Sundar. Have you brought Sundar?
Yes, Your Worship. If I may take Your Worship to para 2 first.
This was basically on the issue whether under 34 solatium is part of compensation. It says no. Under 28 it is part of compensation because there is an enhancement.
Your Worship, in
There is an enhancement.
in Sundar, the question was whether the state is liable to pay interest on the amount envisaged under section 23(2) of the LA Act. That is interest on
The
solatium.
question was this. The question referred to the Constitution bench was, is the state liable to pay interest on the amount envisaged under 23(2) of the Land Acquisition Act 1894?
Which is
In
popularly
other
called
words, the
solatium.
question was whether for the purposes of 28 read with 34, solatium is part of compensation. Now, let's see what the answer says. The question of payment of interest would arise only when the compensation is not paid or deposited on or before the date of taking possession. We are not concerned. It is inequitable that a person who is deprived of the possession of the land on account of acquisition proceeding is not given the amount which law demands him to be paid to him. Any delay thereafter would only be to his detriment. There must be a provision to buffet such iniquity. It is for the purpose of affording relief to the person who is entitled to such compensation when the payment of money is delayed that the provision under section 34 of the Land Acquisition Act has been made. Correct? When the court is of the opinion that collector should have awarded a larger sum as compensation, the court has to direct the collector to pay interest on such excess amount. Right, and this is
Yes.
discretionary. 34
Yes,
is
yes.
mandatory.
Yes.
This is discretionary.
If I may take Your Worship, para 16.
Just a minute, just a minute.
Yes.
The collector to pay interest on such amount. The rate of interest is on a par with the rate indicated in 34. That's right, 9%.
Yes.
This is so provided in 28 of the Act. Thus, interest accrued as per section 34 and section 28 of the Act on the compensation awarded, whether it is as per award initially passed by the collector or by the court later. What is meant by compensation awarded to the question which must be examined? Now come to paragraph where what you want.
Your Worship, para 16. If I may read para 16 again, Your Worship. Para 16. Which Your Lordship just read, para 16.
Just a minute.
Para 16, Your Worship.
Yes.
The para 16, the interest has to accrue as per section 34 and
226 at the bottom.
para 16.
Yes.
Thus, interest has to accrue as per section 34 and section 28 of the Act on the compensation awarded, whether it is as per the award initially passed by the collector or by the court later. So, Your Worship, section 34 and 28 have to be awarded whether it is part of the award initially passed by the collector or by the court later.
This does not.
If I take Your
this
Lordship to
does
para
not depart-
23.
Now, if you read it carefully, yes, para 23.
Para 23, Your Worship.
Yes.
In deciding the question as to what amount would bear interest under section 34 of the Act, a peep into section 31(1) of the Act would be advantageous. That subsection says, on making an award under section 11, the collector shall tender payment of the compensation awarded by him to the persons interested entitled thereto according to the award, and shall pay it to them unless prevented by some one or some more of the contingencies mentioned in the next subsection. The remaining subsections in that provision only deal with contingencies in which the collector has to deposit the amount instead of paying it to the party concerned. It is the legal obligation of the collector to pay the compensation awarded by him to the party entitled. We make it clear that the compensation awarded would include not only the total sum arrived at as per subsection 1 of section 23, but the remaining subsections thereof as well. It is thus clear from section 34 that the expression awarded amount would mean the amount of compensation worked out in accordance with the provisions contained in section 23, including all subsections thereof. So 34 interest
Read-
has to be awarded
read-
on
read-
23,
read
23(1)(a) and 23(2).
Read further, 24.
The proviso to section 34 of the Act makes the position further clear. The proviso says that if such compensation is not paid within 1 year from the date of taking possession of the land, interest shall stand escalated to 15% per annum from the date of expiry of the said period of 1 year on the amount of compensation or part thereof which has not been paid or deposited before the date of such expiry. It is inconceivable that the solatium amount would attract only the escalated rate of interest from the expiry of 1 year, and that there would be no interest on solatium during the preceding period. What the legislature intended was to make the aggregate amount under section 23 of the Act to reach the hands of the person as and when the award is passed, at any rate as soon as he is deprived of the possession of his land.
So this talks about 34 along with solatium.
Yes. And your Worship will see
This
in,
talks of 34 along with the solatium.
no, Your Worship, para 23, last paragraph. Para 23,
Yes.
it is thus clear from section 34 that the expression awarded amount would mean the amount of compensation worked out in accordance with provisions contained in 23,
And not 20.
including all the
No,
subsections.
no, that's right. So 23,
Yes. 23 means the land value under 23(1), 23(1)(a) interest, and 23(2) solatium.
that's it.
So the total aggregate amount,
That's all it. From where do you read that under 28A when there is redetermination?
yes.
So the interest has to be paid on that also, completely.
Your
How
Worship will
can
see-
that be? That cannot be all
No, it-
judgments
it-
till
Your Worship
2022.
will
there.
kindly allow me to rely on the judgment of Pradeep Kumari, 1995, 2 SCC.
We will have it from here. This is
Your Worship, 1995, 2 SCC.
name of the party?
736,
Union of India.
Union of India versus Pradeep Kumari.
Is that 2018?
1995, 2 SCC, 736.
Union of India versus Pradeep Kumar.
If I may read from para 13. May I?
Yes.
Shri Goswami has next contended that while redetermining the amount of
Para.
13, page 744.
Yes.
Shri Goswami has next contended that while redetermining the amount of compensation under section 28A, it is not permissible for the collector to award interest on the additional amount of compensation awarded by him for the reason that under section 28 of the Act,
Wait, that is what the law is.
only the court can direct payment of interest on the excess amount awarded as compensation, and no such power is conferred on the collector, and therefore interest can be awarded by the collector on the additional amount of compensation cannot be awarded by the collector on the additional amount of compensation determined under section 28A. It is no doubt true that under section 28, only the court can direct payment of interest on the excess amount awarded as compensation, and the collector is not competent to award interest on the additional amount of compensation under the said provision. But subsection 2 of section 28A provides that after an application has been submitted under subsection 1 of section 28A, the amount of compensation, the collector after conducting inquiry makes an award determining the amount of compensation payable to the applicants. And under subsection 3 of section 28A, any person who has not accepted the award under subsection 2 may move the collector requiring the matter be referred for determination to the court, and provisions of section 18 to 28 have made applicable to such reference. This would show that after an application has been submitted under 28A1 For redetermination of the amount of compensation, the process of such redetermination results in making of an award by the collector, and a person not accepting the said award can move the collector to refer the matter to the court for determination, and such reference is governed by section
How does it
18.
help
If that is so, section 34 of the Act would be applicable to the award that is made by the collector under subsection 2 of section 28A.
How does it help you, sir?
So in our case also, the collector, on the basis of redetermination the award, awarded us interest under section 34. So there's nothing wrong committed by the collector. The collector,
No, that is not the question. The question is that the issue involved here is that you have been paid because of this confusion in interpretation of 28A and 34.
28 and 34.
First 28. First you got compensation under 34,
Yes.
along with the interest for the delayed payment.
That, 34 is interest for delayed payment.
Forget about, we are asking you for a fact.
Yes.
When you got compensation, before you approached the court, when you got compensation, you were paid interest for the delayed payment. No, because you were not paid anything from the date of assumption of your land.
Yeah, we were paid only crop damage.
That's not for the land, no, it was
Yes.
for the crops.
Yes.
So you were not paid anything.
Yes,
You were not paid anything.
yes, okay.
So you got it along with the interest.
Under 34.
So where has the court enhanced the compensation? Where is the enhancement of compensation?
Bishop, according to my understanding, the enhancement is from 0 to 25. The enhancement is from 0 to 25 because
Unless, for you have to show the case law. Because if no compensation and then, suppose you were granted no compensation. Later it was found that yes, you are entitled for compensation.
Yes.
Then in that case, is it your argument that in that case you will be entitled to compensation and interest on 34 and 28 both, making it 18%? I mean,
Because-
if this is the argument, it is not acceptable to me. Make that argument and we will decline.
according to my understanding, Your Worship, collector awarded 0
You're right.
for land value.
You say the best that you can argue. Look, we are projecting, even as judges, we project the cases of both the parties
Yes.
for us to clearly understand. Now, if you say that this assessment of payment of crops only was not liked, therefore, whatever was done, it has to be, whatever is to be done, it is to be done under 28A. But then the word enhanced becomes, irrelevant, no?
My understanding was that
otherwise
it has been enhanced from 0 to 25.
No. So that you get, that otherwise you get under 34. Could the legislature have intended that in a situation like this, you will get 18%?
Your Worship, my understanding of Sundar is that 28 and 34 are supplementary to each other.
That is,
and
suppose you were paid for land at a rate of 12 per square feet. And thereafter under 28A, it would have been, 28A, it would have been advanced.
Yes.
It would have been advanced to 25. So for the enhanced rate of 15 to 25, you would get it from that date, because why should you be deprived of that? That's what I understand. That's what the section says. The dispute in Sundar was that no, you will not get anything. Absolutely. 34, enhanced. We will not take it as enhanced. Otherwise, it will go.
28 cannot come. Because of the facts of the case.
Because of the facts of the, and there is no enhancement, no?
Your Worship, anyway,
Tell us if we are
Your Worship,
understanding.
My
Tell us-
understanding of Your Lordship's statement is that there was no enhancement at all.
There is no enhancement.
Meaning earlier it was 0, then it was.
Now, can there be an intent of legislature to pay you, 18% on that amount?
18% is available on enhancement. Because even in a judgment of the Maharashtra High Court, where the award was enhanced, the Honorable Maharashtra High Court has granted interest under 28 as well as 34.
We don't consider it to be correct assessment.
But Your Worship, the scheme of the
It
Act
has
is
to
that
be-
yes, interest under 28 and 34 are supplementary to each other.
They are.
Yes,
Who denies?
yes,
The section does not deny, the judgments do not deny.
yes.
It has to come to you, provided you get that. In the facts of this case, you were not paid anything.
So that is, my understanding is, Your Worship, from 0 to 25 is an enhancement.
Then what is 34 then?
No, Your
What
the,
is 34?
the market value has been enhanced from 0 to 25.
Along with interest?
Interest was granted under
See,
34.
The market value was 25.
Yes.
Under 34, you were paid, it should have been paid to you on the date when the land was acquired. Therefore, when you were paid on a later date, you got the interest. And which was at a higher rate. Now you say that now leave this. This is my earning. Now under 28 years, sorry, we don't agree to that proposition. And there is likelihood of confusion everywhere. In fact, we will write here also that this kind of situation now creates confusion. But if you read the act intently, you would understand that this confusion has no scope. Now, no matter how many words, how many paragraphs we may write, but clarificatory sentences are only one. Any other argument?
Your Worship, my learned friend,
Lordship.
can- just one.
In Sundar, Your Lordship, if I may take Your Lordship to Sundar. My Lord, my understanding of the situation is.
No, please don't be so modest. Your understanding, my understanding, let us have a clear understanding of all of us.
Yes, my lord, when the collector passed the award, land value was not included. See, and when land value is included to the award, to the compensation as a whole is enhanced. So, that, my lord, if I may take you to para 3 of Sundar. Because the word used in section 34 and 28 is not market value, it's compensation. And what is the compensation? We have to see, my lord. If I may kindly read, Your Lordship, para 3.
Yes.
Yes. In Union of India versus Ram Mehar, the three-judge bench considered the scope of the expression market value in Section 4.3 of the Land Acquisition Act 1967. By the State Amendment Act, certain changes were effected in the Principal Act. Section 4.3 of the Amendment Act provided that simple interest shall be paid at the rate of 6% per annum of the market value of such land, as determined under Section 23 of the Principal Act, from the date of expiry of 3 years to the date of notification under Section 4.1 of the Principal Act. Learned judges held that solatium cannot form part of the market value of the land. It was also held that market value is only one of the components to be reckoned with the determination of the amount of compensation. The following observation by the bench are highlighted to be the ratio decision. If the market value and compensation were intended by the legislature to have the same meaning, it is difficult to comprehend why the word compensation in section 28 and 34 and not market value was used. The key to the meaning of the word compensation is to be found in section 23(1), and that consists A, of the market value of the land, and B, the sum of 15% of such market value which is stated to be the consideration for the compulsory nature of the acquisition. Market value is therefore only one of the components in determination of the amount of compensation. If the legislature has used the word market value in section 4.3 of the Amending Act 1967, it must be held that it was done deliberately, and what was intended was that interest should be payable on the market value of the land and not on the amount of compensation. Otherwise, there would be no reason why the Parliament should have employed the word compensation in the further provision of the Amending Act. So, my lord, when market value is added to the compensation as a whole is enhanced, Your Lordship. So, compensation means different under section 23. It means crops, it means land value, it means all other benefits. So there's an enhancement in this case, Your Lordship. It is not that a new compensation is given to the private respondents. It is that a market value is added to the compensation. Now the compensation has become big. That is why there's an enhancement, Your Lordship. So that is why the word compensation is used in under section 28 and 34 and not market value. The section doesn't say if market value is paid, then there will be an enhancement.
The difficulty, Mr. Counsel, can I have your name?
Jonathan L. Simon.
Mr. Jonathan. Huh?
Jonathan.
Mr. Jonathan, that creates confusion. Now, you have taken us to paragraph 3 right?
Paragraph?
You have taken us to paragraph 3.
Your Lordship.
Read paragraph 2 first. Clearly,
Yes, my lord.
you would immediately withdraw this argument. Read paragraph 2.
Paragraph 2, Your Lordship.
Read coolly. We are not in a hurry to decide case. It concerns your interest. Lot of money will have to be refunded or adjusted. We can't be harsh to you. Therefore, unless you are satisfied, it is not part of the judges to satisfy the lawyers. It is to satisfy ourselves, but I take special care because there are only 2 cases on board today, so therefore we will take time. Now read that paragraph.
Okay, my lord. Para 2. The power of granting interest on the sums involved in land acquisition proceedings is endowed in 2 provisions of the Act. Section 34 enjoins on the collector to pay interest at 2 tire rates. For the first stage, from the date of taking possession until disbursement of the awarded amount, the rate is 9% per annum. If such disbursement is delayed beyond 1 year, the rate of interest would escalate to 15% per annum from the date of expiry of the said period of 1 year.
Now stop here. So this interest is being paid on the market value. Correct?
No, my lord.
Oof.
From the compensation.
I mean, try and
Because the
understand.
difference between
the compensation that shall be paid on the market value, which shall include
Yes, my lord.
so many things.
Yes.
Now we are trying to understand it from the perspective of 34. What interest? 9% interest taken possession, disbursed. Market value is something else. More things are added for compensation. So interest is paid on compensation. There is no dispute here.
My lord.
Therefore, don't get back to the same question. The issue raised there was that interest would be given only on the market value assessed. No, when compensation is paid and the payment is delayed, the interest is on compensation under 34. No difficulty?
No difficulty.
Now read from here. So it becomes 9% and interest would escalate to 15% per annum from the date of expiry of the said period of 1 year. So you under 34 get a bigger amount. Right? 28 conceives of only 9%. Now read. Section 28 now.
Section 28 of the Act contains the same postulate and it is supplementary
To the above provision. Now how is it supplementary? This is explained. Read.
It empowers the court to direct the collector to pay interest at the above 2 tire rates on the excess of sum awarded by the court.
This is the controlling portion. It directs the collector. Collector can't himself do it. It directs the collector to pay interest. The whole process here is bad. You know, the court only directs the collector. Collector says that no interest has to be awarded. No, he should have said that no. The court should have found. It was not the purpose of the court to delegate it to the collector, because collector can't of himself direct for payment of interest. That's one ground which Mr. Gupta and Mr. Medi can make. Now read this. It empowers the court to direct the collector to pay interest at the above 2-tier rates on the excess sum awarded by the court. So this operates at a later stage when reference is decided. Correct? The real question is whether in calculating the interest, in this context you have to read paragraph 3. The real question is whether in calculating the interest as mentioned in the said provision of the amount of solatium envisaged in 23(2) of the Act should be included in or excluded from the sum on which the interest is liable to be paid. In this context it is said that if you are giving interest on compensation, compensation would not include only market value but would include solatium and other things. It is in this context that Ram Meher's case was quoted. Now read further. That decision was followed by 2-judge bench in Periyar.
That decision was followed by the 2-judge bench of this court in Periyar versus Parikani Robbers Limited versus State of Kerala. Learned judges so in the concluding part of the decision said as follows. Therefore, we have no hesitation to hold that Section 25(3) contemplates payment of interest on solatium to recompensate the owners of the land for loss of user of the land from the date of taking possession till date of payment to court. The word compensation has been advisedly used by the legislature. Accordingly, we hold that the appellant is entitled to interest on solatium. And HUF. Your Lordship,
Just a minute, just a minute. This is therefore, after discussing everything, it says that don't split up compensation. It is not only the market value of land, but all other components, including solatium. And when compensation is being paid under 34, this interest would include everything, even on solatium.
yes. Even
Right.
for the
So
crop-
this is one chapter altogether. Now, what you get and what is enhanced as
It's
the
an enhancement
compensation.
of compensation has been enhanced. So the bubble, my lord, is that there are different components in
Who
the
dis-
ingredients in the compensation. There are different components.
No, no.
One is crop, other is solatium, other is interest, other is land value. So when land value, which was earlier not there as part of the compensation or whatever, but when land value has been added, the compensation as a whole has been enhanced. So there's an enhancement. And your lordship, section 26 would,
Just a
46
minute, just a
of Sundar would make
minute,
it
just a
clear.
minute, let me go through another judgment, so that we are not wrong on any part.
26 का, 26 का, section 28 it is on the compensation, not about
Very clear, there is no difficulty. Section 34, it is mandatory, the interest is on the original award, it excludes solatium unless unpaid. If it is paid, then it becomes part of it. It is not, therefore it is called not part of compensation, and interest is paid on the delay in payment of solatium. So 34 includes this. 28 is inclusive. Because it is enhancement, so therefore the interest would be taken on Solatium also from the last
Yes,
date.
Yes, my lord. Correct, my lord. And my lord, if I might take it to para 26 of Sundar, please, your lordship. Please. Para 26, page 231, your lord.
Yes.
If we think it is useful to quote the reasoning advanced by the Chief Justice S.S. Sundarwalia of the Division Bench of the Punjab and Haryana High Court in State of Haryana versus
Kailashwati.
Kailashwati. Once it is held, as it is inevitably must, that the solution provided for under Section 23(2) of the Act forms an integral and statutory part of the compensation awarded to a landowner. Then, from the plain terms of Section 28 of the Act, it would be evident that the interest is payable on the compensation awarded and not merely on the market value of the land.
Correct. This is not in dispute here, no.
Yes, and my lord.
Here the dispute is something else.
And my lord-
Now why are you taking us to the dispute which was there in Sundar's case? You are not disputing anything with respect to payment of Solatium or the interest under 34. No. You are saying that now pay me interest under 28A. Over and above.
28.
Over and above the interest, Solatium, everything that you have got under 34.
No, my lord. Solatium we have not got under 34. My lord, here is that my basic, whether whether there's an enhancement of compensation in this case.
Bas, that is the only question that you have raised.
My submission, humble submission is, earlier we were paid only for crops, correct?
That is no compensation for land, no.
No, not
So it
compensation,
was,
my lord.
so therein we are
But
making a
Section
distinction.
23 of the LAX, there are different components of compensation.
Why we are reading it like this? Different components, all right. Market value, add,
So market
interest.
value is not a new compensation that has to be.
This argument, if you can bolster it up by other judgments of the Supreme Court, we can understand
Yes.
that if you have considered that I was on the on that portion of land and therefore I must be paid for crops, and that would otherwise also include that a patta holder is a landholder for all practical purposes, therefore give him compensation. This is kind of 3-4 interest added together to give you from the state expense. State expense is not only state of Mizoram, it's the people of Mizoram, their payment. Why should it come to you only?
My lord, my humble submission is that when market value is added to the compensation, whether earlier or later, now the compensation, that is why not market value only. Compensation involves.
Are you
compensation as a
agree?
whole has been enhanced.
Are you agree with anything which was paid to you under 34?
No, your lordship.
Finished. So 28, if you have any straight case law which says that once you were paid for compensation for land, then later, once you were paid compensation for the trees and crops and denied for the land, but it was ultimately found that you are the holder of the land, therefore it is enhanced. If you can show that, we can agree.
Section 26, can't see how Act.
Let's not get back to the same argument over and over again.
My lord,
Yeah, Your Lordship, just one more submission. If I take Your Lordship to section 26,
Yes.
sorry, I'm Your Lordship, section 28. 28, section 28. Section 28, Your Honor. If I may read section 28.
Yes.
Section 28, if the sum which in the opinion of the court the collector ought to have awarded as compensation is in excess of the sum which the collector did award as compensation. The wording is as compensation is in excess of the sum, not on the market value. If the sum which in the opinion of the court
No,
the collector ought to have awarded.
It doesn't talk of market value now.
Yes,
if the sum which in the opinion of the court the collector ought to have awarded as compensation is in excess of the sum which the collector did award as compensation, not the
Then-
market value,
then- yeah,
the
then-
award of the court may direct that the collector shall pay interest on such excess.
Yes.
It's the same thing.
Yeah, my learned friend.
28A is redetermination.
Yeah, my learned friend, the learned counsel for the appellant is saying that earlier there was no market value paid, then it was on the basis of the
No,
judgment
no,
of
that we are not-
the reference court, the market value was given at 25. So he's saying that there was no enhancement, but here section 28 says ought to have awarded as compensation. It does not talk about market value. If the sum which in the opinion of the court, the collector ought to have awarded as compensation, not as market value, Your Worship. Just trying to make a differentiation there, that the wording is as compensation.
That's true. We are not disputing that.
So, Your Worship, Your Worship, since
Let
section,
Supreme Court decide whatever, but I don't think it is correct. Karna? Lagana?
Let us hear this petition.
He will not say that. Yes, anything else that you would like to say?
My lord, one thing I just like to add, my lord, that these landowners, the compensation of these landowners were redetermined under section 28A. These landowners have not filed reference, my lord, petition under section 18. If I may take my lord to section 28A. 28A, my lord. If I may read, my lord, clause 1 and 2, my lord. Clause 1 says, my lord, where in an award under this part, the court allows the applicant any amount of compensation in excess of the amount awarded by the collector under section 11, the person interested in all other land covered by the same notification under section 4, subsection 1, and who are also agreed by the award of the collector may, notwithstanding that they had not made an application to the collector under section 18, by written application to the collector within 3 months from the date of the award of the court, require that the amount of compensation payable to them may be redetermined on the basis of the amount of compensation awarded by the court. Thereafter, my lord, clause 2 says, the collector shall on receipt of an application under subsection 1 conduct an inquiry after giving notice to all the persons interested and after giving a reasonable time opportunity to make an award determining the amount of compensation. So therefore, my lord, this is an award and only interest in the 34 would be payable. It is not an enhancement.
No, that argument is useless. It is notwithstanding that they had not made an application to the collector under section 18. But in
Yes,
this case,
these
they had made an
petitioners have-
application. They had made an
They have
application
not
under
made,
section
they have
18.
not made the application under
they
section 8.
Under 28 is.
No, under 28, under 18.
They have
had
not made
an
application.
He's not understanding. They had made an application under section 18.
No,
that
my lord,
was
they have not
rejected.
made an application under section 18. They have, my lord, section, that's what, my lord, I will just take my lord to,
Asking that the
they have filed a writ petition, my lord, WPC 121 of 2016.
No. These respondents, they had not made any application under section 18 reference code.
No, my lord.
The others who had got, the two of them, they had come before 20.
They have
under
come
18.
before 18. Yes.
And what happened to them?
Yes, my lord. And
they have
my
been
lord,
paid interest under 28 as well as 34.
Huh,
My lord, we'll take page
because
40.
it was enhanced.
Yes,
There they were assessed.
section
Yes.
18 application was filed by some of the landowners.
Two.
Not two, Your Worship, a number
Many.
of. No, though, Your Worship, out of 250 plus landowners, only 2 were holding land settlement certificates. The collector gave them land value. The rest of the landowners were given only crop damage because they were not holders of land settlement certificates. Then, out of those landowners who were not given crop damage, a certain number went to the court under section 18. The court directed that they should be given land value, as given to the LSC, land settlement certificate. So the court directed that they should be given land market value at the rate of 25 per square feet. Accordingly, the collector gave them section market value at the rate of 25 per square feet. Then we filed an application under section 28A, basing our claim on the judgment of the reference court. Then the collector gave us also 25 rupees per square feet. on the basis of the judgment of the reference court. Then those persons who had approached the reference court again filed a miscellaneous application claiming interest under section 28 and 34, which was given to them by the railways on the directions of the collector. Then we moved a representative.
No, what happened to them? Have you asked for a refund?
Yes, my lord, there is an audit, my lord, going by the railway board. There
So
is a
how-
wrong payment made, my lord.
This argument again holds me back. Now, what has happened to others who have been paid? Interest on 34 plus 20, interest on 34 plus 28.
My lord, that is a wrong payment.
Those
my lord.
matters have attained finality. Your
That
Worship.
is a
No
wrong
action has been
payment
taken
made,
by
my lord,
the-
already.
Wrong
inquiry is-
payment made from the same transaction, how can we say no?
No, that's why I submitted, my lord, this is a case under 28A. This is my lord, this is a case under 28A, clause 2. These petitioners did not approach under section 18.
They need not. They need not, the section says so.
Yes, my lord, that
And
section.
there is a judgment of Supreme Court in 2021 which says DDA versus Balakram. It says that even if they have not compensation interest under section 28 may be granted to the by the reference court even if not claimed. Even if not claimed.
But here no award was passed. Here it is award was only passed
We are
under
understanding that
28A.
argument, therefore we were arguing with Mr. Malhotra. You tell us some other landholders under the same circumstances have been paid. How do you deal with it?
No, those.
If you are prepared on that aspect, then please tell us, otherwise don't hold us back unnecessarily.
My lord, so far as the instruction which I have received, my lord,
We will give our introductory understanding and then we'll ask them to say what have they done about others.
Your Worship,
Take up.
regarding payment of interest under 28 and 34 to the other landowners who filed the reference petition, if I may take your Lordship to page 63 of our affidavit in opposition, annexure 7,
Page?
63
No, okay.
of the affidavit in
Annexure
opposition.
7, yes.
Annexure, this is the letter sent by the district collector to the Railways Authority for making payment under section 34.
Do something about that. If that is a final thing, then this is part of the same transaction. We will not make them poorer.
Page 63, annexure 7.
Which affidavit?
67, page, annexure 7. page
Affidavit
60.
filed by the
Let me-
private respondent.
Let us dictate.
Respondent number 1.
No, we are not concluding it today, but we
Yes.
will
Yeah,
speak
just
out
to-
we will speak out our mind and we'll ask them to
Your Worship,
explain.
just
And
to
we can have it in the
part of
Guwahati
the-
bench also.
Just to convince your Lordship that yes, 28 and 34 were paid to the
Yes,
petitioner.
right, right.
Annexure
That's-
7, page.
That's,
That we heard,
that, therefore we are not concluding it today.
Okay.
Otherwise, we are very clear in our minds.
Yeah.
You cannot get payment under both. If that payment has been made, if they don't do anything, you also get.
Under the same transaction, under the same award, number of landowners have already paid interest under 28 and 28 and 34. We are claiming the same clarity, Your Worship.
That's an argument which is difficult to contest. Take it up. We have heard Mr. H. Gupta and S.K. Mr. H. Gupta, learned advocate for the appellant state, and Mr. A.R. Malhotra for response number 1 to 53. A.R. Malhotra assisted by Mr. Jonathan L. Silo for response number 1 to 53. The NF Railways, for construction of railway lines, had acquired a large number of lands located in Kolasib district for construction of railway line from Bhairabi to Sairang by way of award number 1 of 2012. This had displaced approximately 592 landowners whose names found mention in award number 1 of 2012. They were granted compensation for crops but compensation for land was granted only to two of the landowners who were found to be holding land settlement certificates. First up, the remaining 590 of the landowners had only village council passes and annual periodic pattas and annual periodic pattas, which was not taken into consideration as evidence good enough for holding them as landowners. First, the possession of all the land was taken on 13/3/2013. First, the respondents herein fall in the same category of 590 persons who were only paid for the crops and structures built on the land and not for the land. First, out of those 590 owners of village passes, village council passes and annual periodical pattas who were not paid compensation for the land acquired, even though their names were included in award number 1 of 2012, filed reference under section 18 of the Land Acquisition Act 1894 for awarding them the market value of their land. The reference was entertained as LA case number 30 of 2014, which was allowed by judgment and award dated 5/2/2015. By the aforementioned award, those 276 landholders were awarded the land value at the rate of rupees 25 per square feet, along with solatium and interest as per the Land Acquisition Act of 1894. They were also granted additional compensation for market value of the land. First up, this was because the reference court had held that no distinction could be made between owners of land having land settlement certificates and the owners of land having only periodic pattas and village council passes. It is necessary here to state that those persons were also paid 30% solatium on the market value and interest at the rate of 12% per annum. Another set of landowners approached the district collector for redetermination of the amount of compensation payable to them by filing an application under section 28A of the Land Acquisition Act 1894, which was rejected by order dated 11/5/2016 by the deputy collector. Against the aforesaid rejection, a writ petition was filed by 63 of the writ petitioners by WPC number 121 of 2016. The High Court remanded the matter back to the district collector for considering the case of the writ petitioners in accordance with law by following the provisions laid down under 28A of the Land Acquisition Act 1894. Full stop. Accordingly, the DC Colasib, by its order dated 28/10/2016, made assessment under Section 28A of the Land Acquisition Act 1894 and directed for payment of compensation by order date, directed for order of compensation. This emboldened the other writ petitioners also to approach the High Court for payment of compensation, payment of interest under 28A.
28.
Under 28. Full stop. In that instance, again, the court had directed, the High Court had directed the DC to look into the matter. Full stop. Ultimately, they were also paid.
If I make just, the landowners in LA 30 of 2014 reference petition who were granted market value solution interest, subsequently Annexure 6, page 45, they filed a miscellaneous application claiming
ठीक है,
interest.
that aspect need not be stated.
Which was
Mr.
granted to
Everything
them.
everything is not necessary. What have I said? To look into the matter, whereafter again they were paid interest on the enhanced value of land under 28A of the Act. First up, however, the same appears to have been denied to the respondents herein, who
No, they were
opposed.
paid, my lord, I'm sorry, my lord. My lord, they were paid under 34, page 105 of my writ appeal, my lord, after the reassessment was done by the order dated 28/10/16, my lord, page 105.
That cannot be done.
paid
No wonder.
interest
After reassessment
under
was done,
34.
they were paid compensation after the award. First of
No,
the
no.
the same was denied to the respondents herein, who too approached this court and got the matter remanded to the DC Colasib for necessary redetermination, pursuant to which they got an order in their favor. Full stop. The appellant herein challenged such assessment and prayed for setting aside such impugned letter of assessment dated 7/12/2022 made by the District Collector Colasib and the consequential letter of District Collector Colasib dated 10/5/2023, and sought a direction not to give effect to the impugned letter of assessment and the consequent letter, and further sought direction from the court to adjust the amount which was paid under Section 34 of the LA Act to the 41 respondents mentioned in paragraph 11 of the writ petition, with the interest payable under Section 28 of the LA Act 1894. Such a prayer was disallowed by the learned single judge by holding that benefit of interest under Section 34 of the LA Act, benefit of interest under Section 38 and 28 of the LA Act are complementary to each other. 28 and 34 are complementary to each other, and there was no reason found, and therefore there was no reason found for quashing of such assessment of the district collector or for ordering of any such set off against the compensation already paid for, against the interest on compensation already paid for under section 34 of the Act. First up, we have examined the judgment and have gone through the facts of this case. First up, the position of law is very clear by now. Under section 34 of the Act of 1894, interest is required to be paid on the compensation awarded by the collector. Full stop. When the amount of such compensation is not paid or deposited on or before taking possession of the land, the collector shall be under an obligation to pay the amount awarded with interest thereon at the rate of 9% per annum from the time of so taking possession until it has been so paid or deposited. First up, the rate would increase to 15% after 1 year by 1 year, which is by way of an amendment carried out in the main act in the year 1984. First up, interest under section 34 applies to the original compensation amount determined by the collector under section 11. First up, this interest is mandatory and not discretionary, and it arises from the delay in payment of the awarded amount. Whereas interest under section 28 is the interest on excess compensation. Full stop. If a sum which, in the opinion of the court, the collector ought to have awarded as compensation, is in excess of the sum which the collector did award as compensation, the court may direct that the collector shall pay interest on such excess at the rate of 9% per annum from the date on which he took possession of the land to the date of payment of such excess by the court. First, this section therefore applies only when the reference court enhances the compensation under section 18. First up, there is yet another distinction which is required to be noticed, that interest under section 28 is discretionary and applies only to the excess amount determined by the court. First up, in the present case, the appellant state is questioning the assessment under section 28 on the ground that the respondents were not held to be landowners, and therefore the compensation which was paid to them initially was only with respect to the crops and structures. First up, it was only later that by the order of the courts, the distinction between landowners holding land settlement certificates and village passes and pattas was blurred, that compensation was paid for the first time under section 34 including interest thereupon under section 34 with interest thereupon under section 34. Some of the landowners, on litigating the issue, were granted further compensation under 28A, which was never questioned by the appellant state. Full stop. In the present case, the assessment has been made by the district collector in the same vein, VEIN, holding the respondents to be entitled to interest under 34 and 28A both.
28.
28 both. First up, this contention is based on the ground that the provisions contained in section 28 and 34 are complementary and supplementary to each other, and that when they were only paid for the crops and structures and not paid for the land, which was paid only later with the intervention of the court, this was definitely an enhancement, attracting the provision contained in section 28 of the Act, and therefore their entitlement for interest under 34 as also under 28. The argument is sought to be repelled by the appellant on the ground that it would not have had been the intention of the legislature to provide the landholders with double interest from the same date under 34 and 28. The provision has been included only to ensure that the value of the land must reach the landholder, and he cannot be denied the interest component on it if the court finds that the award declared by the collector and paid to them was not commensurate and thought it good to enhance the compensation amount. Thus, provision has been made under section 28 for interest in the same terms as in 34 on the enhanced amount. On the enhanced amount. Both sides have relied on Sundar versus Union of India 2001 7 SCC 211, but the issue raised here does not appear to have been answered in the aforenoted judgment. To further specify, the issue involved in the present case is whether the interference of the court in declaring that the respondents also are landholders whose lands have been appropriated by the NF Railways would amount to enhancement of compensation because they were earlier paid only for the crops and structures. If the compensation granted to them under 34 is taken to be a compensation of the land value of the value of the land plus other entitlements adding up to the compensation amount, then whether this situation could be termed as an enhancement of compensation directed by the court, incurring the liability of the state to pay interest under section 28 of the Act as well. We were about to decide this case when Mr. Malhotra, learned advocate for the respondent, has submitted that many of the landholders under the same transaction were paid interest under 34 and 28 as well, which is not sought to be annulled or varied or assigned by the state, and therefore any attempt at divesting them of the benefits which has accrued to them by virtue of the orders of this court should not be taken away. The learned Mr. Gupta, learned advocate for the appellant, submits that he will get back to the issue after taking necessary instructions. Let this case come up for consideration sometimes in January.
My lord, one case, my lord, in principal bench fixed for 3 appeal of Isle bench, my lord. I am the counsel for the appeal, and it is fixed on 4th of December, my lord. This is related to 28 and 34 interest, my lord.
On 4th of December, along with
4th of
it is in Guwahati bench.
Yes, my lord, it is, your lordship heard this matter, it is already, I also give the short note also, my lord, before this honorable submit, my lord. It was, my lord.
Any difficulty?
The facts may be slightly different, if I'm not mistaken.
But then we'll do it there.
Yes.
You can appear virtually, Mr. Malhotra.
Yes, if your lordship allows us to appear virtually.
Why not? What have I said?
Let this matter be listed.
For consideration on so and so, along with, give the name, give the number.
Read appeal 265 of 2023.
On which date?
4th of December.
4th of December.
On 4th of December. On 4th of December, full stop. The records of the present case may be transferred to the Guwahati bench for the needful. Full stop. Mr. Malhotra and Mr. Silo, learned advocates for the respondent, submits that they would have no difficulty in appearing before the court virtually on the said date. Full stop. Next, Meliko, contempt. Let this contempt petition also be listed along with the aforenoted appeals on the same day.
Only, my lord, is the, so for respondent 11, my lord, he is retired, my lord.
What is it?
Respondent 11 in contempt petition, my lord.
It's okay, you say it on that day.
Yes, my lord.
Irrelevant facts
Brilliant.
as if you're...
Item 3.
I'm obliged.
Issue निकल गया ना बहुत clear. Issue is very clear.
I was slightly unclear.
May it please, my lords.
मैं तो ये पढ़ता हूँ तो मैं डिटेल में पढ़ता हूँ. And I read in detail. Question for friend. Yes.
My lords, in compliance of the order dated 24/10/2025,
Yes.
an affidavit was filed on behalf of the respondent number 7, my lord, on 28 October, wherein we had stated the period of completion. And if I may take your lordship to annexure 3, page 16, my lord,
Yes.
of the affidavit,
Yes.
dated 28 October 2025, my lord.
They are doing their part.
It's a short paragraph, my lord.
This is a lifeline they are supposed to. So we will say that on the next date give us the updated short date. December? Take it up. All right, we are satisfied that you are doing something. But then this is not a concession.
Yes, my lord.
This is something which you have to do. That's the lifeline.
Yes, my lord.
And we would not dispose this off, notwithstanding the fact that we are satisfied that you are not sitting tight over the matter.
Yes, my lord.
But then we'll keep it pending to have an updated report on 4th of December again. Take it?
If
January. No, November can be. Nothing can be done.
What about the private respondent, the newly implemented private respondent number 7?
As per our affidavit, my lord, we had sent a letter, communication letter, dated 27/10/2025, my lord.
We'll say that if he doesn't appear, we'll issue non-bailable warrant of arrest. Has he been served?
yes, my lord.
What has been done?
The letter is at annexure to page 15, my lord. It's just a 2-paragraph letter sent to the contractor, my lord.
No, so we are not doing anything, you inform him.
Yes, my lord.
You
Will
inform
do.
him on the next date. If he doesn't appear, we will consider the possibility, the feasibility and possibility and the need for issuing bailable warrant of arrest against him.
Yes, my lord.
Page?
He can't
Page
run away.
15, annexure 2, my lord.
4 o'clock.
Okay.
3:55.
3:55 पता करा फ्लाइट उड़ रही है कि फिर ट्रेन से जाना होगा ट्रेन से जाना होगा तो और केस मंगा कर take it.
My lord, if your lordship may allow me, in the meantime, I would like to submit that there had been an accident in the NH 306 stretch recently.
There has been an accident.
Yes, my lord, and a life has been lost in that regard, a truck driver.
That's a different issue, madam, altogether. That's an
That is
absolutely
because of
different
the
issue.
dilapidated situation of the road, my lord.
Very bad. No, but they
I
have
would
taken
like
up-
to
they have
submit
taken up
newspaper clippings regarding that, my lord.
No, so we are keeping it by the end of November. You will have to give another date.
Yes, ma'am.
My brother says that if there is any, and I agree that if there is any let up in the work, we will hold you responsible. NHIDC, you have taken it over from PWD.
Only in the month of July 2025.
So this is, we are in November.
Yes, my lord, but due to
Look
monsoon,
at this.
monsoon, my lord.
Somebody has lost his life because of bad road.
If I may, my lord, due to the heavy rainfalls, the
You
road,
can't always hide yourself under vis majeure. Under force majeure, not vis majeure. Force majeure. You are aware that this place attracts lot of rains.
yes, my lord.
And so, why do you have to make road which gets washed in one rain?
It was earlier.
Suppose there is unprecedented rain in say other parts of the country
Yes, my lord.
where it's always dry, we can understand. But you have to make roads to take into account such, contingencies of heavy rains.
My lord, earlier it was under the state PWD, my lord.
We have followed that.
Yes,
Haven't we ourselves said? We have followed that. Again, for the consumption of the bar, when you repeat your arguments more than twice, the court gets the feeling that either the lawyers are thinking that the judges are hard of hearing, or judges are not understanding what the lawyers are saying. Now, in both the cases, the bench gets irritated. Because we are not hard of hearing, number one, and number two, we understand. Correct? So make your submission, and in order to ensure that it has been conveyed across the board, you can make another repetition. But you keep on repeating that doesn't, for me it doesn't, I don't feel good. My brother may be very indulgent, but for me it doesn't feel good. And you say once, repeat it again, not third time. What you say keeps registering in my mind. All right? This is don't take it as any anger or something. This is an advisory, otherwise also. Repetition in courtroom is not good. Take them.
Letter by the NHIDC, they have informed the judge.
Available warrant of arrest, is it?
I think so. He was also talking that they'll finish it in June 2023.
Will issue.
It is scheduled to be.
Take them. Can I mean? We have heard Ms. Emily L. Changte. Say correct pronunciation?
Yes, my lord.
Changte, learned advocate for the petitioner, and Mr. Samuel V. Changte for respondent number 7 to 10. Who is the central government council?
Zaram Sangpui.
Hmm?
Zaram Sangpui number 2.
Zaram
Sangpui. Sangpui.
MS Zaram Sangpui Learned Central Government Council for respondent number 6 has also been heard. Full stop. Mr. Ram Murmu, you were sitting so far off. Mr. Ram Murmu also has appeared for respondent number 11.
And Your Lordship, I am appearing for the state government, respondent number 1 to 5.
What's your name?
Vane Isyami.
उसको ठीक से कर देना सब एक जगह many times. MS Siami appears for the Leonard State Council appears for response number 1 to 5. This writ petition, this PIL, this PIL had been filed bringing to the notice of this court the deliberate inaction of the respondents in not undertaking necessary repair / construction and upgradation work in the national highway stretch of NH 306 and 06 in the state of Mizoram, specifically the Konpui Khamrang Sairang stretch from 118 kilometers to 159 kilometers on NH 6. As directed by this court, an affidavit has been filed on behalf of respondent number 7, 8, 9 and 10 stating that the worst affected stretch between Kanpui to Khamrang from 118 kilometers to 130 kilometers has only recently been taken over from Public Works Department by them, has only been recently in July 2025 has been taken over from Public Works Department. It has also been informed that short-term maintenance work from Bikhauthir to Kolasib from 70 kilometers to 95 kilometers and Konpui to Khamrang from 118 kilometers to 133 kilometers and Buichali to Sairang from 147.8 kilometers to 159 kilometers has been awarded to MSJ Infratech on 4/6/2025, who, even though having been informed by this court to appear,
Haven't been informed by the NHIDC.
who though having been informed by the respondents to appear before this court, has chosen not to appear. The work order has been given to him on 7/7/2025. There is a short-term maintenance contract also for Khamrang to Buchai. छोड़ दो उसको. The portion of land, the responsibility for the portion of road taken up by the respondents, by the answering respondents, is being repaired by taking up emergency work of filling up of potholes with boulders, clearing of landslides and drains, constructing retaining walls and culverts at critical locations. Stop. It has been submitted that because of heavy rains this monsoon, the condition of the road became very bad, and even while repair work was being undertaken, comma, completion got delayed because of incessant rains and also the heavy traffic on that road. With respect to the current status, comma, the respondents have tried to explain that they are doing as much as they can and also assure this court that very shortly the responsibility undertaken by the respondents would be discharged. We are, as on date, not satisfied, and we would like another updated report with photographs of the concerned stretches of the national highway in question on the next date by way of an affidavit to lend assurance to us that work in right earnest is being carried out.
The same should be submitted by respondent number 12, the contractor.
A separate affidavit on the next date shall be filed by respondent number 12, comma, the contractor who has been entrusted with the work. As a measure of last indulgence, we direct the respondent number 11 to appear before this court with an affidavit regarding the updated report of the work done by him. Mr. Samuel, learned advocate, has offered to inform respondent number 11.
12.
Respondent number 12?
12.
11. Oh,
12. 12.
12. Herein also is 12. He is the same person. Respondent number 12. वो कर देना उसको 11 हम सोचे दूसरा है. Respondent number 12. Respondent number 12. Shall inform respondent number 12. What have I said? 12 to appear before this court on the next date. First up. Failing his appearance on the next date, we would consider the desirability of issuing warrant of arrest against him to compel his attendance. First up. We are saying so for the reason that the road in question is the lifeline in the state of Mizoram, which is in bad state. First up. MS Emily has informed this court that recently, because of the bad road condition, an accident took place in which one person has lost his life. The matter assumes alarming. The matter thus assumes alarming proportions, which must be dealt with in the same manner by the respondents. Let this matter come up for consideration on 25th of November. My brother will be here. All right. I will come back again. Don't worry.